Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. Like I try to do each and every Thursday night, here to go over questions about debt, garnishment, bankruptcy, and all those other horrible things that are out there. Appreciate everybody checking in tonight and those who may be watching this at a later time. Again, as founder of the Consumer Warrior YouTube channel, why I did that is because I'm an attorney in the state of Arizona. I help people with serious debt problems. We deal with consumer bankruptcies, wage garnishments, debt collection lawsuits. And what I found in my law practice here in Arizona is when I talk to people, everybody goes to this horrible place in their mind when they deal with these things. And really just having some information, some knowledge about what it is that you're dealing with, maybe what some options are to deal with it, can provide a lot of peace of mind and alleviate some of the stress and anxiety that you're dealing with. So what I provide here is information. It's not legal advice. While I am a licensed attorney, this is just some guy talking on YouTube, so take it for what it's worth. If you're in the state of Arizona, you'll notice that my information is below my phone number here, and you can also, there's a link to set up a consultation. I do all the consultations myself, so you'll speak with me if you call in, and I'm happy to give you some advice. If you're not in the state of Arizona, unfortunately, I cannot represent you because of the licensing issues. So, before we get started, one thing that I recommend to everybody who comes to the live stream each and every week is our good sponsor, SoloSuit. SoloSuit is an awesome company. They use technology to help people, provide them with tools for things like drafting answers to debt collection lawsuits, debt settlement, compelling arbitration. There's a link in the chat section. Click on there. It's a good way to help yourself, help the channel, and get where you need to be to get some of these things in the rearview mirror. So what I like to do each week is, if you do have a question, go ahead and put it in the chat section, whether you're watching on Facebook or whether you're watching on YouTube. I'll put it up on the screen and we'll discuss it, and I'll give you some different thoughts and maybe approaches on how to deal with things. Now, this one is here nice and early. Says, I have a voluntary repossession and the car is a total loss. I owed $18,000 in Ally Bank and I live in Pennsylvania. What do you recommend? So when it comes to repossession, if you have a car loan, you can't afford the car loan, it gets repossessed, or like this one, if it was in an accident or something like that, what happens is there's a formal process in each state, and it is very state specific as far as what's required. But typically what they do is they will then sell the vehicle at an auction. They usually get next to nothing for it. And then if there's a balance to still owe, that's called the deficiency balance. And then they have a period of time to file a lawsuit to collect on that. In Arizona, it's 4 years, 4-year statute of limitations after the repossession occurs, after they sell it. And there's usually a bunch of noticing requirements that they have to provide as far as telling you when they sold it, how they sold it, all that kind of stuff. And so in a situation like this, if they take the car, you still owe 18 grand. Yeah, there's going to be a deficiency, particularly if the car is totaled or if it doesn't run or something like that. They're going to have an $18,000 deficiency balance. They'll likely sue you for that balance, with the whole goal being to get a judgment so they can garnish wages, bank accounts, all that kind of stuff. So, as far as your options, you can reach out to the lender and try to settle it. They'll usually send you a letter and say, hey, if you don't settle this out pretty quick, we're going to sue you for it. Because if they sue you, then you're left with trying to contest it. One option is usually, and again, very state specific, but you need to look at the different statutes and see if they did everything they were supposed to do. If they dotted all the I's, crossed all the T's when it came to the repossession and the sale of the vehicle. There may be some ability to avoid a judgment that way. Or alternatively, a lot of people look at a bankruptcy option. Chapter 7 bankruptcy will wipe this out completely as far as the deficiency balance, and allow you to move forward. Chapter 13 as well, it'll eliminate it, but there's likely going to be something that has to be paid on it going forward. So hopefully that's helpful. Some of the comments on the YouTube channel that I thought was a good one that I wanted to bring up. This one says, if a debt collector is a private party and is demanding all my personal information, bank statements, pay stubs, etc., is there a way to protect myself from identity theft and further harassment? This is a really good question. And I see this in debt collection lawsuits when people are representing themselves. I see it with me as well when I'm representing people, but we object to it. And that is, if the debt collector has filed a lawsuit, they're coming after you and they want all this information from you, they're saying, hey, and usually they do it in written discovery. They send over a request for production of documents saying, we would like your last 2 years of tax returns, bank statements, pay stubs, all that kind of stuff. Or sometimes you even see it when there's no settlement in place or there's no lawsuit in place and they're trying to settle the debt. And they say, look, we're not going to settle this unless you give us all your bank statements, pay stubs. If no lawsuit has been filed, you got to be very careful with this because what they're doing is you are giving them a road map to all of your assets, to wage garnishment, bank levy. Same thing if a lawsuit's filed, but if the lawsuit has been filed, unless they have a judgment, I would object to those requests. They're going to request them because a lot of people just turn them over. A lot of people don't realize with written discovery, if you send over a request for production of documents, that you can object to it because most states are not going to allow them to get your financial information if they don't have a judgment against you. Now, if they get a judgment against you, things change. But prior to getting a judgment, they're not entitled to that information. Or I'd object. I wouldn't turn it over. I'd put up a fight over that. Now, if they have a judgment, there's post-judgment discovery. If you went through the lawsuit, went to trial and lost, or if it's summary judgment and you lost, they can usually serve post-judgment discovery. They can do what's called the judgment debtors exam or like a deposition. They can request bank statements, pay stubs, all that kind of stuff, and then you're going to have to turn it over. I often tell people, there's no jail in debt collection. However, at least in Arizona, if you get a judgment against you and they set up a judgment debtors exam and you don't show up, the court can hold you in contempt and then they'll issue a civil arrest warrant. So that's the one area where jail is a possibility. So you got to be really careful there. If there's anything like that, where there's a court order requiring you to appear. All right. This one said, if you file a Chapter 7 bankruptcy and plan on doing a reaffirmation, will they approve it if you've never made a single payment on the vehicle? So good question. So the reaffirmation agreements, these are like the bane of my existence. There's something, I used to say this is the kind of a new requirement. This is 2005, they redid the bankruptcy code, and this is one of the things they put in there, these reaffirmation agreements. Let me tell you what that is. If you go into a Chapter 7 bankruptcy and you have a car loan, the bankruptcy code states if you want to keep the car, you need to enter into a reaffirmation agreement. And what this is, it's kind of like a new contract, because basically contracts that you entered into prior to bankruptcy are often, the debts can be eliminated. However, with a car loan, a secured debt where there's collateral, a property attached to it, you're required to sign a reaffirmation agreement saying, I'm going to keep the car and reaffirm the terms of my contract and just continue to make the payment on it. Now, there's some preconditions to a reaffirmation agreement. If you're behind on the payments, if you're several months behind on it, the creditor is not going to provide you with a reaffirmation agreement. They're likely going to file what's called a motion for relief from the automatic stay so that they can repossess the vehicle. So you got to be current on it. So in this question here asking, are you going to have to do a reaffirmation if you've never made a single payment? Well, if you've never made a single payment and you're behind 6 months, no, you're not going to be able to reaffirm it. If the car is brand new, if you bought it just prior to filing, then yes, you're going to enter into a reaffirmation agreement. I can tell you that in Arizona, reaffirmation agreements, the judges typically do not approve them. The reason why is because if they approve the reaffirmation agreement, then it's a situation where if something happens down the road and they have to repossess the vehicle, it kind of goes back to our first question, they can actually come and get the vehicle and then sue you for the balance. Whereas if the judge doesn't approve the reaffirmation agreement, at least in Arizona, the way they do it is you can keep the car, continue to make the payments on it. But if you were to lose the car down the road, they can't come after you for the balance because technically it was discharged in your bankruptcy. It really gets into the weeds of it, and it's kind of a big old pain, but it's something where something that just to be aware of. So being current on it is going to be the main thing there. It's important to know as well, and this has come up recently. A lot of creditors will really browbeat consumers who go through Chapter 7 who don't reaffirm their debt on a car loan, even though they're keeping the payments current. And because one of the things that they don't have to do, they don't have to report your on-time payments to the credit reporting agencies. They just don't report at all. So they stop reporting, period, and it's a little frustrating. The courts, there's a court in California and a court in Arizona. They both held trials on this. They brought in representatives from Experian, Equifax, TransUnion, the big credit reporting agencies, and they all testified under oath saying car loans after bankruptcy on an old car loan doesn't make that much difference. They said it's almost no difference at all, which I know doesn't make a lot of sense, but they say, look, you already did the bankruptcy that caused the damage. Your credit will get better with time, but it's not going to get better just because you reaffirmed a car loan. So something to think about there. All right, let's jump into some of the questions here. LF says, been on long-term disability for the last year and a half. My credit card is getting out of control because of low income. I'm thinking bankruptcy. I have $150,000 in equity car note, half paid off, 150 equity in a $425,000 home that I don't want to lose. Okay, I'm guessing you meant $15,000 of equity in a car note, unless you have a super nice car. Maybe you do. But $150,000 car. So yeah, some equity in your home. Part of it. So let me tell you how bankruptcy works. With a Chapter 7 bankruptcy, you need to write your debts down into two categories. There's unsecured, three categories: unsecured, unsecured priority, and secured debt. Now, secured debts are any debts with collateral or property attached to them. So you think of like your mortgage loan, home loans, car loans, motorcycles, trailers, boats, ATVs, RVs, anything like that, where the loan and the property are connected. Those are your secured debts. They're in Chapter 7 bankruptcy. The main thing you need to think, if I owe money on it and I want to keep it, I just have to keep making the payments on it. That's generally true, because even in a situation like this where your house has some equity in it, in most states, there's a homestead exemption that'll protect the equity. Now, it varies from state to state, so you got to be careful. Like in Arizona right now, the homestead exemption protects $414,000 of equity. So LF, if you live in Arizona, you're going to be fine, because as long as you keep making the house payment, you have $150,000 of equity, you're going to be fine. However, I know in some states, I think it was like Kentucky has like a $20,000 homestead. You would not be okay in a Chapter 7 there. So this is why it's important. If you're looking to file bankruptcy and you have some equity and some assets, you need to talk to a bankruptcy attorney in your particular state. Otherwise, it can run into some issues there. So let me get to those other categories. So there's secured, unsecured debts in Chapter 7, credit cards, medical bills, personal loans. Those are typically just wiped out completely. And then unsecured priority debts, child support, taxes, those types of things don't go away in a Chapter 7. You're going to have to continue to pay those generally. Same with student loans. They're not priority debts, but they fall into that category. So hopefully that's helpful there. Carla says, I'm in Tennessee, sued by Synchrony for a credit card debt. Haven't filed an answer yet because I'm nervous about how to file and going to court. Can't afford an attorney. Best advice for going through this when you're alone. Most people do. Truthfully, less than 2%, I think, were the stats I've seen of people who get sued by debt collectors have attorneys. That being said, 95% of people don't respond. And Carla, a lot of it's because of what you're talking about there. There's this nervousness and anxiety about what do I do? And so some people are just into, they freeze and they don't do anything. You don't want to do that. You want to file an answer. Filing an answer will buy you time. It'll give you opportunities to present defenses. Synchrony often sells their debt, so you're probably dealing with a junk debt buyer, which means that you're dealing with even more defenses. So you can watch the videos here. It's a great resource. Check out the solo suit link at the top in YouTube. That's a link to, they have a product there that helps you to draft an answer and file it with the court. Again, that'll help you from going into any type of default on this. The main thing if you're going to represent yourself in this, I warn people, it kind of takes over your life. You go to work all day and you're going to come home and you're going to have to get up to speed on it. Go to the court's website, see if they have any self-help resources. You could contact the state bar in your state, see if there's any pro bono attorneys, or sometimes there's a self-represented clinic or something that'll kind of help you out. The main thing is you need to kind of see, particularly if it's like a smaller type debt, like a small claims or something like that, you can work your way through that and you should be fine. I have a ton of resources here on the website. Solo suits are a great one to get it started on. Filing the answer, like I said, if you don't file an answer, they just get everything they're asking for, plus attorney fees, plus court costs, and it just turns into a giant mess. So I would recommend starting there and then contacting your court and seeing if they have some type of self-help center to help you through that. All right. Follow up here. Do you recommend Chapter 7 after receive the notice letter about the deficiency balance? Well, like I said, the Chapter 7 will eliminate it completely. It'll discharge it. It'll go away. The question is if everything else. It's usually not just one debt, but sometimes the one debt will kind of push you over the edge. If there's other credit cards, medical bills, personal loans, that are causing problems, then yeah, it'd be a good way to get some debt relief. It's through a Chapter 7 filing. You do have to qualify for a Chapter 7, and they base that on a means test. So they look at the number of people in your household. They take a snapshot of your income over the last 6 months and determine if you qualify for it. But if you do qualify for it, Chapter 7, I don't sugarcoat it. There's obviously consequences to it, but there's also a lot of kind of scary stuff online that's just not true. It's on your credit report for 10 years. Most people recover in about 18 to 24 months. FHA, VA, they'll do mortgage loans again after a Chapter 7, 2 years after a Chapter 7. Other lenders are 3. My clients always tell me within weeks after filing the case, they have car loan applications, credit card applications just blowing up their mailbox. So just something to be aware of. It's not the end of the world. You'll recover from it and be able to move forward. So, all right. You know what? This one was right here ahead. Shaka says, can you touch on options about after a judgment is filed, appeal, motion to set aside, judgment, and such? Yeah. So, I mean, if a judgment is entered, and there's usually a couple ways judgment gets entered in debt collection lawsuits. If it goes to trial, the court rules against you. If there's a motion for summary judgment and that's granted, then you're going to have a judgment against you. The time to file an appeal is usually very limited. Like in the justice courts in Arizona, you have 14 days. Superior courts, you have 30 days. And it's serious as can be. If you miss that by 1 hour, you're done. There's no appeal rights. So if you need to find out when the judgment was entered and make sure that you're still within your appeal timeline. Before you appeal, here's my caveat. An appeal is different than most people think it is. If you're appealing a judgment to a higher court, it's not that you get a new trial or they're going to, it's basically what the appellate court's job is to look and see what the lower court did and see if they followed the rules in most circumstances. Sometimes the summary judgment's a little bit different. They'll do what's called de novo review, meaning they'll review everything over. But if you go to trial and lose, they're going to look to what the judge did and see, did the judge abuse his or her discretion? And the problem with that for most consumers that are appealing it, one, you had to have made appropriate objections at trial. Otherwise, they're waived on appeal. A lot of times that's a struggle for people who don't do this all day long, like guys like me do. Or even if you did that, I have had appellate judges tell me, look, I wouldn't have done it that way if I was the judge. I don't agree with that ruling, but it's within the judge's discretion to rule that way. And so it wasn't so far out of bounds that they're going to let it stand. So often I don't see appeals being, a big thing. If you've been on my YouTube channel, I actually do an appellate argument before the Arizona Court of Appeals, before a 3-judge panel on a Midland funding case. That was an appeal that the creditor filed. The one and only time in my career that the creditor has filed an appeal. I went to the Court of Appeals and we ended up with oral argument on it. That was Midland funding. Their attorneys filed that. We had won a trial and they appealed it, and it was upheld on trial. We still won. So maybe that's why they don't file appeals anymore. The other option is the motion to set aside, like you were talking there. Usually it's called a motion for a new trial. If you feel like there was some irregularity or if the judge made a ruling that was contrary to the law of your state, you can file a motion for a new trial. The deadline in most jurisdictions is 15 days after the court enters its ruling. It's the judgment. You're able to file a motion for a new trial on that. If you do appeal it, there are bonds, typically cost bonds. Some jurisdictions require a bond for the full amount. Other jurisdictions, they say you don't have to file a bond, but the creditor can start collections on the judgment if you don't do that. So it gets kind of complicated. Appeals can be tricky. Definitely something to talk to an attorney about. All right. Hercules says, I'm a defendant in a debt collection lawsuit. The plaintiff filed a motion for summary judgment or for summary disposition. And I replied, now they claim they have my credit card info. name, account information, yada, yada, yada. Despite my argument that my account wasn't included in the bill of sale, how should I respond? What's the best strategy to challenge this? So, if what you're saying here is pretty normal. So they have, particularly a junk debt buyer, they have the bill of sale. It's fairly generic. It will say, the accounts are attached as Exhibit A, or sometimes it says they're listed on the computer file and it has like a computer file. And then they always attach this spreadsheet. And I always say, where in the world did this thing come from? And there might even be something at the bottom saying this was taken from data from X and X computer file. I still make an objection to that particular document coming in. Lack of foundation. It's hearsay under Rule 803.6 because it wasn't part of the original document as well. Rule 106 in the Rules of Evidence states that this doctrine of completeness, if they're going to give you the bill of sale, they've got to give you the actual exhibit to it, not something that somebody typed up after the fact. I would also go through it very carefully to make sure that all the information lines up. On more than one occasion, I go through there. They've got account numbers wrong. They've got balances wrong. They've addresses wrong, particularly if you have a common name. If your name's Hercules, that might not be. So check those kind of things out. And then if it is something where, it looks like that this is going to be not in your favor, that's when you can really engage in settlement discussions at that point. So, all right, let's see here. There was one other thing I wanted to touch base on from the comments. Said, if you surrender your car to the lender, will that go into a Chapter 7 as well? There's kind of a lot of questions, and we started off with the repossession question. The answer is yes. You can surrender your car through a Chapter 7 bankruptcy, and you won't owe anything on it any further. And typically, you don't have to surrender it for a couple months into the bankruptcy. So as long as you keep the insurance current on it, you can keep using it even though you're not paying it, and then surrender it through the bankruptcy at that point. So, but you won't owe anything on it, and it will go away completely. So, all right, I think we'll wrap it up there tonight. But hey, thanks for everybody for checking in. Go over and check out the people over at Solo Suit. They do a great job in supporting the channel, and they have a lot of great tools that help you with filing an answer to a collection lawsuit, motions to compel arbitration, a pretty slick debt settlement tool, all those kind of things to be able to help you out. And then check back on the channel. We'll be here each and every week, and I will see you next week.